Is it true that you can get free gas and electricity at your property throughout the United Kingdom? Is it true that you already pay for these through your income taxes? Who owns the meter at your property? Can you change the meter? Can you refuse to have a smart meter installed? Can you refuse to provide meter readings to your energy company? These are questions that I hope to address in this video, because many of you, my viewers, have sent me emails to tell me that there are various videos and claims in groups and forums going around making all sorts of wild and outlandish claims about gas and electricity, and you'd like me to address them. So in this video, I would like to address one video in particular that is from a channel of Richard Vobes. No criticism intended of Richard himself, but obviously Richard has guests on his channel. It's, I would hope, for entertainment purposes. And so I would like to go through one of those videos that many of you have sent me in particular, where he has a guest that makes various claims about free gas and electricity throughout the UK. And so I feel it my duty to address one or two of those claims. But for those of you that are new to me, my name is Daniel Shensmith. I am a barrister of England and Wales, and I enjoy helping you to understand law on this channel. And I've done that for many years now, over many thousands of videos. So please do subscribe. There'll be something in the library for you to enjoy. So without further ado, let's move to this video to address some of those claims.
Well, by popular request, a lady from up north has agreed to come on and says we can have free energy nationwide.
Now, I would like to think that many of you will agree that if it sounds too good to be true, it's probably too good to be true. Now, the very idea of free gas and electricity is palpably ridiculous. I'm quite certain that Richard doesn't believe this himself, and I would like to think that this is just a channel for entertainment. But alas, some of his guests make wild claims of this nature, so I feel it necessary to address them. If you do want something for free, however, there is a link floating around at the bottom of the screen, whereby if you switch your energy supplier to Octopus Energy, which I'll discuss later in this video, you will receive £50 credit on your account, all for free. And I get a kickback as well. So full disclosure, but the link is on screen and in the description below. But for now, let's move back to the video.
Utility bills specifically are already prepaid through our income taxes.
Now, this idea that they're already paid for by income taxes appears to be the underlying principle throughout these claims, but it's fundamentally untrue. But a little bit of digging later, I get some ideas to where this notion has come from. That is that the government does have a spending on the energy sector, but it's not in the way that is claimed here. It is not from your income taxes, at least not for the consumption of your electricity, which Richard's guest goes on to explain. But rather, it is spending in a number of different ways. And you can see just recently, now you'll recall that the government assisted in energy bills just in the last year or two. And this is represented on this graph here. But you can see for many years, there's been a spending in the energy sector. And this is the government's way of supporting the energy sector in a number of different ways. It is not, however, for the regular consumption by every household across the United Kingdom. But let's go back to the video.
The last house that we moved into, we had smart meters. They were already fitted.
So now we're moving on to smart meters. Now, yes, you might move into a house. It might already have smart meters fitted. It might have an old-fashioned traditional meter, which is not a smart, regular meter reading meter. And you need someone to come and take the meter readings, or you need to send them to the energy company. But regardless of the meter that's installed, its job is to measure the consumption of gas and electricity.
So we removed them and we just put mid-certified standard meters in.
Now, the notion of removing them is itself quite precarious, not least of which because if you don't own the meter and it belongs to the energy company, then you cannot remove it. And if you are removing it with the intention of preventing it from registering the consumption, then that itself might amount to an offence, because under the Electricity Act 1989, and there's a similar piece of legislation for gas, of course, under Section 11, it provides for the interference with meters. This is where somebody alters the register of any meter or prevents any such meter, so it would include those that are already installed, from duly registering the quantity of electricity supplied. Anyone doing that will be guilty of an offence. And not only that, the supplier, under subsection 3, may discontinue the supply of electricity to the premises until the matter has been remedied. So many people claiming that the supplier cannot cut you off, they can cut you off. There's a number of different statutory provisions that allows the company to discontinue the supply of gas and or electricity to that premises. One of which being if there's been an interference with the meter, including removing it and replacing it with another one. Unless, of course, you've done it with their consent, which many people have discussed having conversations with the energy company and they say, yes, you can switch it for your own meter. If they say so, that's fine. But it's worth bearing in mind as well that once you've got a smart meter, you cannot go back to a traditional meter. But let's go back to the video and see what else is said.
And that's not illegal, that's not a crime, etc.
But obviously, I've just outlined, if it is for interference with the meter, then it is illegal and it is a crime. Let's carry on.
You may find yourself with a locksmith, a representative waving a warrant of entry outside of the house. That's always a possibility.
It is a possibility, but I believe that this is being put across in such a way as to trivialise such a thing. Whereas if a warrant has been issued, that is an order of the court to come to fit a meter where people have refused under the legislation. So it's not something to be taken lightly, because if you resist a warrant in those situations, you'll be committing a further offence. But let's carry on.
So you can find a no trespass notice.
A no trespass notice is not going to negate the power of a warrant ordered by a court. Much like if you put up a notice on your door to say that you're removing the implied right of access to your property. It's near enough the same thing. It's not quite the same thing. No trespassing, well, trespassing itself is a civil wrong in and of itself. If you commit any further act that is aggravating that trespass, then it becomes aggravated trespass, which is a criminal offence. Trespass can be criminal in certain areas, such as railways, crown property, and certain other land as well. But we digress. But putting up a notice to say no trespassers or that you're removing the implied right of access does nothing to negate the authority of a warrant issued by a court for somebody to visit the property to forcefully, if necessary, install or replace a meter.
The actual concept is very easy about replacing your own meter. So the meters, wherever you live, wherever the situation, whether you rent, you're in a council property, a housing association, or you own the property, you can remove the meter that's in there. And obviously we've built a small team of engineers that are awakened, as I call it.
Right.
Yes, a lot of engineers are indoctrinated through the training, but a lot of us are that are still in the matrix.
Right. So part of that is correct in that regardless of what property you're in, if you have permission of the energy company, or if you can show that you own the meter, then you can replace it with a qualified engineer. But only if you have permission of the energy company, if they own the meter. And if you do it yourself because you own the meter, then you still need to report those meter readings back to the energy company. Now, the reference to a small group of engineers that are prepared to do this suggests that some of them may be prepared to break the law. And it would be an offence to replace the meter without the appropriate permissions. Whereas most engineers will flat out refuse to replace a meter unless, of course, they're acting under the instruction of or the permission of the electricity or the gas supplier. But let's move on.
So they can take the meter out, we put it back, fit a new meter, brand new meter that's non-smart, because that's important.
Now, smart versus non-smart, energy companies are not now installing anything other than a smart meter unless maybe they have one available and your preference is to have a traditional one. But if they don't have one, they won't install it. If you can get hold of one and you have permission of the energy company to install it, then that might be possible. But otherwise, they will install a smart meter. But regardless of it being a smart meter or a traditional meter, you still need to report the meter readings back to the energy company. all of which we'll come back to in a moment. And also, if it's a smart meter, you can put it into what's referred to as dumb mode, so it's not smart anymore. It acts as a traditional meter and doesn't automatically report meter readings back, but that's another story.
But this meter is not attached to any database that's shared amongst all of these suppliers, and we'll call them suppliers because that's what a lot of people know them as.
Right, so there's two things there. First of all, the database referred to the meter and the suppliers, the implication being made here that they're not actually supplying, which they are, but I'll come back to that. But as to the meter and it being on a database, that is referring to the fact that it needs to be registered with the local network operator, the DNO, the distribution network operator. And there are a number of different places you can look up your own DNO, but that's the database that she's referring to.
That's all they are. What they do is they rent the serial number on the back of the meters. That's all they have. They don't own the meters either.
Now, as I've said, some energy companies do own the meters. Some of them don't. Some of them are already installed at the properties, but some of the energy companies very much do own these meters.
Electricity is being generated somewhere, and some people say that they're nicking it from the ether, and most people think it's being generated by all sorts of different mechanisms like the solar panel and the wind farms and coal things and what have you. So it's generated somehow, and then it's piped down to you through the wires, and it hits your box, and at that point you're metered, and then it goes into yours, and then however much it's recorded.
Now that so far is the most accurate explanation of what happens. Energy is generated, it's sent through the network, which is owned and operated by National Grid, and part of your bill goes towards National Grid for the maintenance of the network. And yes, then it hits your box, then it is recorded and metered, and off the back of those readings, your bill is produced from your energy supplier, which I'll explain in a moment, and that's how you know how much to pay for your gas and electricity.
But National Grid already get paid through our income taxes via the government.
Again, that is not true. You do not pay for National Grid through your income taxes, although the government does have a spending on the energy sector, some of which may be going towards certain infrastructure around the UK to do with energy. But the vast majority of National Grid's infrastructure is paid by way of bills that come to you via your energy companies. So part of your energy bill is made up of the consumption, the vast majority of it, but part of it every year is also going towards National Grid, which is the distribution network. That is how it is paid, not through your income taxes.
So the electricity is already bought and paid for?
Yes, energy consumption.
Again, that's fundamentally untrue. It's not paid for through your income taxes.
You can do freedom of information requests to these Eons, Scottish Powers, etc. to ask them, do you supply electric and gas? Do you own the wires, the pipe? Do you own the meters? Very reluctant to answer certain questions as well. They always most likely refer you back to the National Grid.
Now, the reason they'll refer people back to the National Grid is because part of those questions are, do you own the wires and the networks and everything else? So for those, yes, they will refer you back to National Grid because it's National Grid that operates the network. If you ask, do you own the meter? They might say, well, yes, we do. No, we don't. Or we don't know. Because if the house has been bought and sold several times and someone's in the meantime has replaced it themselves with permission of the previous energy supplier, the new one doesn't necessarily know. That's why some of this information is not available, not because this is somehow some big revelation, aha moment that all you pay for is renting a meter. That's frankly nonsense, but let's carry on.
Right.
But we've had a couple of them in email to show that they will tell you, you can change your meters if you like.
Yes, because they don't object. That's all that means. The energy company is saying, yeah, sure, knock yourself out, go and change the meter, as long as you report back to us. I'll come back to law in a moment, but let's carry on.
But it's got to be by a qualified engineer.
Again, like I said, it has to be by a qualified engineer and with the energy company's permission. And if you're doing it in such a way to interfere with it, as I said, we've covered that legislation, which makes that an offence. But back to the video.
Point being that you're removing the meter that's in the property
Yes.
Because you don't want to use a meter that the brokers have on their database, because that's what they're charging you for, the service of that meter.
Now, this is where it crosses into territory which is very likely going to get a lot of people into trouble, because it comes back to this legislation. The implication here, from my understanding of what's being said in this video, and it's my opinion based on what's been said and based on the law, is that the suggestion of removing the meter is so that the information is not being relayed through any database and not being relayed to your energy company. If that is the case, then it's with the intention of avoiding and therefore tampering with the meter readings, which would make this a criminal offence. So anyone watching this, I would strongly suggest you don't follow that guidance, because if you are found to be interfering with the meter, you'll be guilty of an offence. But let's move back to the video.
You have that put back in and you gain energy in exactly the same way as you did before. You just don't have to send meter readings anywhere.
And that confirms what I've just said. I quote, "You're receiving energy in exactly the same way as you were before, but you don't have to send energy readings back to the energy company." Now, that is both interference with the meter, as it says here. If any person intentionally or by culpable negligence alters the register or prevents any such meter from duly registering the quantity, he'll be liable of an offence. But this is also covered under the Theft Act of 1968 under Section 13, which is the abstraction of electricity. A person who dishonestly uses without authority or dishonestly causes to be wasted or diverted any electricity shall, on conviction on indictment, be liable to imprisonment for a term not exceeding 5 years. So this is an indictable only offence, because there's no option here for a summary trial. So abstraction of electricity, i.e. the dishonest usage of electricity without authority, with the intention of not paying for it, as this video suggests, not giving the meter readings to the energy company, amounts to abstracting electricity, which is a criminal offence and indictable only. That means it will only go to the Crown Court and attracts a prison term of 5 years for dishonest abstraction of electricity. Let's move back to the video.
It's not, Richard, that we're doing anything untoward, that we're just not contributing to society, because it's already prepaid.
And there's the fundamental misunderstanding. It hasn't already been prepaid, because it isn't paid through income taxes. It's paid directly to the energy companies. And I'll come back to that in a moment, but that's why it's wrong.
We're through our income taxes. So when we buy food, when we buy clothes, etc., everything's included. We've got a government expenditure report.
And that refers to the expenditure report, which I mentioned earlier, which, as you can see here, there is government spending in the energy sector, but it is not in the way that's implied in this interview. And it is not just as when you buy clothes and you pay your income taxes and everything else. It is nothing to do with any of that.
It's a massive scam. It's fraud.
So let's talk about the contract then, because you give them the jurisdiction, or you consent to them supplying you effectively nothing.
Yes.
Because it's already there, and you're agreeing to pay several £100s a month.
Yeah, you say contract. It's not. There's a verbal contract based on you giving them information.
Now, again, regardless whether it's a verbal contract, a written contract, most of them will be written contracts because they will send you an agreement. But in the event that you haven't signed anything or you haven't even spoken to them, and some people trying to convince you that there is no contract for those reasons, again, the law jumps in to correct that position. Because in Schedule 6, Section 3, there is a provision for deemed contracts in certain situations, which provides that where an electricity supplier supplies electricity to any premises other than in pursuance of a contract, the supplier shall be deemed to have contracted with the occupier for the supply of electricity as from the time when he began to supply electricity. So whether they like it or not, by way of legislation, as a matter of law, there is a contract in place for the supply of electricity, which therefore means it needs to be paid for.
Have you got to wait to the end of that contract and then go, I'm free, like John Inman?
No, you certainly don't. because you're not in a contract, it's invalid because you
Yes.
don't actually receive such document.
And again, that, as I said, that's not true. Either you receive confirmation from your energy supplier or you see it in the legislation. It is a deemed contract. Just like in consumer rights legislation, terms are implied into a contract whether the trader likes it or not. Whether they agree to those terms or not, whether they like those terms or not, they are implied into the contract. They don't have to be written anywhere. They don't have to be spoken, certainly don't have to be signed. And even if they were to make a contract to say these don't apply, they do apply. Even if you agree they don't, that's called contracting out. You cannot contract out of a statutory implied term, or in this case, a statutory implied contract of supply. So it's there in black and white.
There's lots of different approaches, because there's the formal approaches where you could do a notice of conditional acceptance, and you say, okay, I'm going to accept your claim because they're claiming that they supply that property, right? But I'm going to withhold from paying until you can provide me evidence of a contract.
Well, in those cases, if you accept the claim that they supply the property, you'll be liable for the charges for the use of that electricity and gas. If you say until they supply you with the contract, that's fine. They will just supply you with documentation that says you are in contract with them. And if not, you're already in contract. As I said in the legislation, you are already in contract regardless, because it's a matter of law. Even if they haven't provided you a written contract, they are deemed to have contracted with you by supplying the property. But now moving to the notion that runs throughout that video that suggests that these companies don't produce the energy that they supply you. Let's just explain something for a moment. There are energy generators and there are energy suppliers. Some companies are both. For example, Octopus Energy are one of Europe's largest investors in renewables. They operate £4 billion worth of green energy generators across 7 different countries. They claim to be investing in enough wind power for 500,000 homes. They're investing £3 billion in green hydrogen for heavy industry. And they are building one of the world's largest wind turbines. In fact, there's a very interesting video by Octopus Energy which takes you on a world tour of all of their energy sites throughout the world. And as you can see here, as you zoom in, this video takes you through a virtual tour. This is a solar farm in Abbots Ripton. Then it moves to another one, jumping around various different countries, over 7 different countries. Another solar farm here. So I'll link this video in the description below. This takes you through a number of different sites that they own and operate to generate electricity. But as to the generation, you can see here a graph of wholesale electricity generation across different companies. And then you can see here the demand by sector. So just under a third for industry, just under a third for domestic, and so on. So how this really works is that these generators generate the electricity. Then there is a wholesale supply of energy, gas and electricity. This is then purchased by the energy suppliers and resold to you, the consumer. And the amount that you use, which is measured through your meter, is then billed to you by your energy supplier. As I said, some suppliers are both generators and suppliers. But as for swapping out meters, this is contained within the Electricity Act 1989, Schedule 7. Essentially provides that when someone is supplied and charged for electricity, it is to be measured through a meter. But this also provides that if the supplier agrees, the meter may be provided by the customer, who may provide a meter which belongs to him or is made available otherwise than in pursuance with arrangements made by the supplier. But otherwise, it shall be provided by the authorized supplier, who may provide a meter which belongs to them or another person. So in other words, if the energy supplier agrees, you can supply the meter, or you can supply it with someone that the energy company has suggested provides the meter. If not, then it is to be provided by the energy supplier, because it says here in black and white, otherwise it shall be provided by the authorized supplier. Now, there is a reasonable aspect to this, and that is that an authorized supplier may refuse to allow a customer to provide a meter only if there are reasonable grounds for his refusal. If there are no reasonable grounds to refuse, the energy company is unlikely to refuse. That doesn't affect the requirement to meter the power used and to report that back to the energy company. In the event that power is taken without permission, aside from it being a criminal offence, of course, there is also a provision for this, where supplies of electricity is illegally taken. Where any person takes a supply of electricity which is in the course of being conveyed by an electricity distributor, the distributor shall be entitled to recover from that person the value of the electricity so taken. So it's a statutory provision that they can recover from the customer the value of the energy for which they have not paid. So there's no argument here. If it's been used and not paid for, then there's a statutory provision to recover it from the debtor. And there are all sorts of other provisions for entering the premises, to check the equipment, to repair the equipment, to discontinue the supply if it hasn't been paid for. But either way, as we come back to Schedule 7, where a customer of an authorised supplier is to be charged for his supply wholly or partly by reference to the quantity of electricity supplied, the supply shall be given through and the quantity measured by an appropriate meter. So in conclusion, the energy is generated, it is supplied either by the company that generated it or through another supplier that's bought it on the wholesale market. They resell it to you, the consumer. It is measured through a meter, which is either owned by them or it's owned by you. It could be owned by you if you've changed it with their permission. It's measured, metered, and those readings are then provided to the energy company, which is also in the legislation, and then you pay for it. If you don't pay it, they can cut you off. They can sue you for the amount, and you can be prosecuted for abstraction of electricity, which is an indictable offence if it's proved that you dishonestly abstracted electricity from the supplier. So I know that's a lot to take in, and I've barely scratched the surface of the legislation. It's very complicated, and most people generally go with the flow. But the problem that I've seen here, and I've read some of the comments where people genuinely think that this might be real, that you get free electricity because you've already paid for it somehow, which you haven't. Some of whom are genuinely questioning this in groups, and other people are telling them, no, it's fine, that doesn't apply. But in those cases, some people are inadvertently giving wrong legal advice. Now, there's nothing to prevent somebody from giving legal advice. The problem is they won't be insured to do so, because you won't get insurance to give legal advice on a professional indemnity basis unless you are a qualified lawyer. Both my firm and I have separate professional indemnity insurance for providing legal advice and representation, because I'm a registered barrister. Now, if you are not a registered practicing lawyer, you won't get insurance against giving negligent advice, which is what some people, I feel, are doing in some of the comment sections on certain groups that I've looked at. So if you are part of this group and giving other people advice, I would suggest you don't do that, because if you're wrong, you could be sued for giving negligent advice. Worse still, you could be an accomplice to what ultimately amounts to a crime. So I hope this video has served to clarify some of those questions. And just remember, if it sounds too good to be true, it is almost certainly too good to be true. But thanks for watching, and I'll see you next time.